Okay, let's get into this because this is the epic tale of essentially the beginning origin story. Wolverine was involved of Social Security benefits. A lot of you are thinking this is a boring topic, but it's not. We had no idea as a country what the hell we were going to do with this whole idea called Social Security benefits. It was one of those things where it was passed into law, and then everybody thought, well, somebody going to sue. And then when they sue, we're going to actually know if this thing's going to stay as a law or whether or not it's just going to die in the vine. Because it could die in the vine. It could die in the vine. The court could have kicked it down. This was a document prepared by the Social Security Administration, but specifically Larry DeWitt, an SSA historian, in 1999. Okay, so we're talking over 20 years ago. Let's get to it. It's an interesting read. It's pretty good, but it explains, everybody's always hearing me talk about 1937, blah, 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 things got shitty, and then people are like, oh, what else happened? This is the story. This is the beautiful Disney-like tale of a princess who met a prince and just messed it all up thereafter. Let's get into it. Preparing a report and transforming that report into a law. While heroic in scope in many ways, it is not always the end of the story. Even though the Social Security Act was enacted into law on August 14th, 1935. So remember, 2 years before 1937 when the big decision came out. August 14th, 1935, the country still had to hear from the Supreme Court. This was a new, untested area of federal authority, and it was inevitable that it would be challenged in the courts. And until the Supreme Court ruled, no one could be sure that the nascent Social Security Act would survive its infancy. The constitutional basis of the Social Security Act was uncertain, right? Because they didn't know how to form this thing properly. They didn't know if it was going to stick with the tax-based constitutional provisions. They didn't know. They were just making this stuff up as they go. They were Indiana Jones in it. The basic problem is that under the reserve clause of the Constitution, the 10th Amendment, powers not specifically granted to the federal government are reserved for the states or the people. That's you, the people. Now, when the federal government seeks to expand its influence in new areas, it must find some basis in the Constitution to justify its actions. Obviously, the Constitution did not specifically mention the operation of a social insurance system as a power granted to the federal government. Okay, because they weren't thinking about socialism when they were framing it in that way. This is, what I mean? Come on, yeah. Obviously, the Constitution did not specifically mention the operation of a social insurance program. The Committee on Economic Security, CES, struggled with this and was unsure whether to claim the Commerce Clause or the broad power to levy taxes and expend funds to provide for the general welfare as the basis for the programs in the Act. Remember, if it went with the Commerce Clause, you guys would all be way better off today. But they didn't. They went with the Taxation Clause because, shit, why not? Why not? Here we go. Ultimately, the CES opted for the taxing power as the basis for the new program. And the Congress agreed. They said more taxes sounds like the future of how we're going to run this thing. But how the courts would see this choice was very much an open question. Okay, so a dispute among the founders. The constitutional issue about the taxing power had deep roots running all the way back to the founders and to a dispute between Alexander Hamilton and James Madison. Although both Hamilton and Madison were Federalists who believed in a strong federal government, they disagreed over the interpretation of the Constitution's permission for the government to levy taxes and spend money to provide for the general welfare. Because let's call it like it is. A, it's super ambiguous, and B, it's an easy way to money grab and be very Britishy. So yeah. Hamilton thought this meant that the government could levy new taxes and undertake new spending if doing so improved the general welfare in a broad sense. Madison thought the federal government could only expend money for purposes specifically enumerated in the Constitution. So you have a generalist, right, who's like, let's just do what we want to do. And then you have a constitutionalist, a federalist ESDist, the most federalist ES. And that basically, the person was like, yeah, we're going this direction because, we want to make sure that it's not too broad. We don't want people going ahead and, just spending and taking, as a government, taxing for wherever they want. Obviously, the government now just taxes us for whatever the hell it wants. So the end of the story, but let's keep going. The Madisonian view, also shared by Thomas Jefferson, came in time to be known as the strict construction doctrine, while the Hamiltonian view is called the doctrine of implied powers. All right. The balance between these two philosophies went one way and then the other over the years, with Hamilton's view tending to prevail over the long run. But it was always possible that in uncharted waters, the courts might retreat to Madisonian conservatism, and the Supreme Court on the early New Deal era was highly conservative in outlook. Okay, so put another way, do we have the power to create this massive socialism-based program to tax money from people, not give them any rights, and then give them that money back when they're older? Because remember, back then it was just retirement. Back then there was no disability benefits, there was no SSI benefits, there was none of that. There was no disabled adult child, there was none of that stuff. None of that stuff existed. It was just retirement benefits. Okay. The AAA and the Social Security Act. Already in 1934, lower courts had begun overturning major parts of the New Deal program. It was not holding up. Potentially the most serious threat came from rulings invalidating the Agricultural Adjustment Act, the AAA, which used the same broad power to levy taxes for the general welfare as the basis for its program of agricultural price supports and controls. Lower courts ruled this unconstitutional. The Supreme Court followed in January 1936, ruling that a statutory plan to regulate and control agricultural production is a matter beyond the powers delegated to the federal government. So they're saying this is more powers held by the people, powers held by the state, and basically they were conservative. They didn't want to go ahead and expand the government's capabilities, because then it's they could just do whatever they want, like they do right now. Yep. Yeah. There was a silver lining in the cloud, however, because the same opinion ultimately sided with the Hamilton on the larger question of a strict or flexible interpretation of the general welfare clause by holding that the power of Congress to authorize expenditure of public monies for public purposes is not limited by the direct grants of legislative power found in the Constitution. That's important. Let me read it again. The power of the Congress to authorize expenditure of public monies for public purposes is not limited by the direct grants of legislative power found in the Constitution. And this is where the liberalization started and everything went to hell. Now, the Supreme Court's ruling on the AAA was a major rebuff for the New Deal and was important for Social Security as well, since it seemed to portend what lay ahead for the Social Security Act. I mean, literally the year before the SSA Supreme Court ruling came. I mean, we're talking timelines were squeezed on this one. The AAA was an attempt to rescue farmers from the collapse of the farm economy that happened with the coming of the Depression. It sought to control, kind of like what we're going through right now with milk. Just saying. I'm not trying to, I'm just saying. It sought to control agricultural production in order to stabilize prices and restore farming to profitability. The actual mechanism by which this control was to be achieved was to levy a tax on processing of foodstuffs and to use the proceeds from this tax to fund agricultural subsidies, in effect using the subsidies as incentives to control production. Paying farmers not to produce too much or paying some other farmers to produce just enough, stuff like that. Fearing how the courts would see this new function of government, the framers of the AAA deliberately placed the tax provisions and the subsidy provisions in separate titles of the act, so they could argue that they were not necessarily connected to each other. That is, so they could argue that the purpose of the tax was not to control production, but was merely to raise revenue, even though it obviously existed to control production, which we see all the time now. Like when you ask farmers, okay, like big farms, big ranches, stuff like that, are they subsidized by the government? A lot of them are. Now, with that said, this was the same strategy adopted by the framers of the Social Security Act, and they did a trial tactic, right? So when they created this big document, they put the scary stuff in one pocket, and then they put the other scary stuff in another pocket, And they were rolling the dice to see whether or not the courts would beat one side down but allow the other, or beat the other side down, allow the other, or beat both sides down or allow both to continue forward. Okay. This was the same strategy adopted by the framers for the Social Security Act, as can be seen in separate titles 2, retirement, and 8 of the original Social Security Act. The old age insurance system introduced in the Social Security Act was designed as a public policy level to be a contributory social insurance program in which contributions were made by workers to what was called the Old Age Reserve Account, with the clear idea that this account would then be the source of monies to fund the workers' retirement. Whole idea is Americans were way better at saving back in the day, right? But still, there wasn't a good plan for when people got old. Now you move to the current day where nobody is good at saving for the most part. And ironically, it seems that retirement benefits should be doing a heck of a lot more. Now, also, Diana Fernandez, thank you for the $2 donation. That's awesome. Very, very cool. Very awesome. And then also, I don't know if you sent the $5 donation, but whatchamacall, I'll check for it later. Deb Carter, thank you. You gifted a disability benefit membership. That's very cool. That was gifted to Jim Young. Awesome. Very, very cool. Okay, so actuarial studies were done to determine what the contribution rate would need to be in order to have sufficient reserves in the account to pay anticipated benefits, right? And then ever since then, the actuaries have been getting it wrong. But that's okay. That's okay. They can graph it. We just know that it's falling like a moon into the earth. It's not good. All right. In the popular understanding of the program, the contributions established an earned right to the eventual benefits. Let me read that to you again. In the popular understanding of the program, the contributions established an earned right to the eventual benefits. President Roosevelt strenuously objected to any attempt to introduce general revenue funding into the program, which they ended up doing with SSI. His famous quote on the importance of the payroll taxes was, "We put those payroll contributions there so as to give contributors a legal, moral, and political right to collect their pensions and unemployment benefits. With those taxes in there, no damn politician can ever scrap my Social Security program." And he was right. He was right. He carved out special taxes just for those programs. So the whole idea is that those programs existed, the tax money was there, they were specially separated, so it made sense that they couldn't change who was going to get what. Now, we all know the whole idea of people having a legal, a moral, and a political right to those funds is total BS. But that's where the Supreme Court comes in. All right. Conceptually, the old age insurance program was a social insurance program with an obvious connection between the taxes collected in Title 8 of the Act and benefits paid in Title 2 of the Act. The taxing and spending provisions of the Act were placed in separate titles in the vain hope of convincing the courts that what was obvious was not the case. That is, so that the argument could be made that the taxing and spending provisions had nothing to do with each other. Whether such a strategy would work was highly questionable, especially following the ruling on the AAA, agricultural people. But as it would turn out, the court itself would change in ways that rendered the strategy moot and the Social Security Act safe from legal challenges. Now, the president tries to pack a court. So remember how people were hearing from Biden and Obama about expanding, the Supreme Court and things like that. This is something that goes way back, right? How many individuals are going to be on the Supreme Court? And if you add more Supreme Court justices, you can potentially, change the landscape and the culture of the Supreme Court. When people always tell me the Supreme Court doesn't make law, yeah, just like how the Supreme Court doesn't have a lien, right? Just how it doesn't have a lien, right? It doesn't lean, doesn't lean. In early 1937, President Roosevelt made what, and what's funny about that comment? They put that comment so much in that one video that I did about the Supreme Court ruling. God, the Supreme Court doesn't make law. It doesn't make rules. It just interprets them. Okay. Literally, they made a law, the Social Security, and it had different titles back then, but Social Security benefits, right? Specifically for, and they waited for the Supreme Court to bless it in how it would actually be applied. And when something is figured out on how it's going to be applied, that's called making law. Just for everybody else that's questioning where that comes from or how it works, that's what it is. In early 1937, President Roosevelt made what turned out to be the biggest political blunder of his career. And yet it was a blunder that would have fortuitous, even pivotal importance to the fate of Social Security. Federal judges are appointed for life. The Supreme Court of the 1930s was the most elderly in the history of the Republic, with an average age of over 71. And remember, back then, that was even older than it is today. President Roosevelt would derisively refer to them as those 9 old men. Actually, he only had 4 of them in mind. The court was split down the middle in political terms. On the liberal side were 3 justices sympathetic to the New Deal programs. And then you had Brandy Stone and Cardozo. Cardozo is like famous beyond famous, just like ultra famous. On the conservative side were 4 justices who voted against everything the Congress and the administration tried to do. McReynolds, Butler, Van Devanter, and Sutherland. In the middle were Chief Justice, the middle, the splitter, the halvesy, Chief Justice Charles Evans Hughes, and Justice Owen Roberts, who were often swing votes on many issues. In the spring of 1937, Justice Roberts joined with the conservatives to invalidate the Railroad Retirement Act. In May, the court threw out a centerpiece of the New Deal, the National Industry Recovery Act. In January of 1936, a passionately split court ruled the Agricultural Adjustment Act unconstitutional. So everybody thought back then, or at least a lot of people, that the Social Security program of the New Deal was just going to get scrapped. They were going to throw it out, go figure it out again. It's not going to work. And they thought this because of the taxation, which ironically is what came to our undoing when it comes to us not being able to sue the federal government when, applying a general legal private ownership right to those benefits that we pay in. In another case from the 1936, the court ruled New York state minimum wage law unconstitutional. The upshot was that major social and political reforms, including social insurance programs, appeared headed for defeat. This despite the obvious will of the electorate, who returned Roosevelt to office in 1936 with the largest landslide in history. Yeah. It's going to be interesting what happens in a couple of months. President Roosevelt's response to all of this was stunning and unexpected. On February 5th, 1937, the year that the Supreme Court ruled on it, he sent a special message to Congress proposing legislation granting the president new powers to add additional judges to all federal courts whenever there were sitting judges aged 70 or older who refused to retire. Wink, wink. Get where we're going with this? Cool. Couching his argument as a reform to help relieve the workload burden on the courts. President Roosevelt's unusually blunt language made it clear that he really had in mind a part of the problem of obtaining a sufficient number of judges to dispose of cases is the capacity of the judges themselves. So, you get a lot of cases, the judges are old, they're not really figuring them out fast enough. The bottom line is, even back in 1937, they had an issue with old people not knowing when to step down and let somebody take a shot at it before the party basically fumbles a football like they've never fumbled before. I'm not making a political statement. I'm reading history, damn it. All right. This brings forward the question of aged or infirm judges. Although you can see where I'm going with it. A subject of delicacy. I like the words, the phrasing, the joyous syllables that are being used right now in this wonderful little writing. This is definitely my as a writing, it's my beautiful little poison. I can feel the love in it. Okay, here we go. Question of age or infirm judges, a subject of delicacy, and yet one which requires frank discussion. God, you could even apply this today. Like, you could just, all right, I'll skip it. In exceptional cases, of course, judges, like other men, retain to an advanced age full mental and physical vigor. Those not so fortunate are often unable to perceive their own infirmities. A lower mental or physical vigor leads men to avoid an examination of complicated and changed conditions. Little by little, new facts come, and become blurred through old glasses fitted as if it were for the needs of another generation. Older men, assuming that the scene is the same as it was in the past, cease to explore or inquire into the present or the future. In other words, old people live a culture that doesn't really make sense anymore, and so using super old judges doesn't help with us moving the courts forward in creating new laws as to what society actually wants them to go with. That's what they're really saying there. Okay. All right. The practical effect of this proposal was that the president would get to appoint 6 new justices to the Supreme Court and 44 judges to the lower federal courts, thus instantly tipping the political balance on the court dramatically in his favor. The debate of his proposal was heated, widespread, and over in 6 months. Done. Gone. The president would be decisively rebuffed, his reputation and history tarnished for all time, which is weird because when the Democrats were presenting this argument relatively recently that they were going to add more Supreme Courts, like they should have just studied President Roosevelt's blunder. They should have they knew what would happen. They knew people are not kosher with that. But the court, it seemed, got the message and suddenly shifted its course. James, thank you for the $5 donation. That's absolutely awesome. Yeah, I can definitely post the link for the article. Absolutely, absolutely. But the court, it seems, so what's interesting is that the president, Roosevelt, basically did a baddie to the judges, and the judges responded with, "Oh, we'll fix you, bro. We'll fix you, bro." And that's ironically why we have the system that we do today for Social Security benefits. And that's funny. Like if you take the big fixes that we had with President Clinton for the Social Security Administration and didn't have a Monica Lewinsky situation, a lot of the problems would not exist that we have today with it. It literally was an Oval Office Lewinsky situation that stopped us. One would say, and I quote, stunning and expected political blunder. Some would say the Lewinsky Oval Office situation was also quite a political blunder. Some would say. All right, here we go. But the court, it seemed, got the message and suddenly shifted its course, beginning with a set of decisions in March, April, and May of 1937, including the Social Security Act cases. The court would sustain a series of New Deal legislation, producing a constitutional revolution in the age of Roosevelt. All right, so here's the basic thing. The Supreme Court cases. Oh, actually, let me read to you the switch in time part. It's important. It's a good piece. It'll help you out. Despite the intense controversy the court packing plan provoked and the divided loyalties it produced even among the president's supporters, the legislation appeared headed for passage when the court itself made a sudden shift that took the wind out of the president's sails. In March 1937, a pivotal case occurred. Justice Roberts unexpectedly changed his allegiance from the conservatives to the liberals, shifting the balance on the court from 5-4 to 5-4 in favor of most New Deal legislation. So literally, we have the Social Security Administration, we have some of the details in the AAA Act, we have a lot of this stuff because the president tried to put shade on the Supreme Court justices who were old, and they didn't like being called out for being old and potentially having more people take a seat next to them that were younger. In the March case, Justice Roberts voted to uphold a minimum wage law in Washington state, just like the one he had earlier found to be unconstitutional in New York state. Remember how people are telling me that Supreme Court justices just interpret the law and they don't make the law? Please stop saying they don't make the law. They make law. They make law. 2 weeks later, he voted to uphold the National Labor Relations Act, and in May, he voted to uphold the Social Security Act. This sudden change in the court's center of gravity meant that the pressure on the New Deal supporters lessened, and they felt free to oppose the president's plan. This sudden switch by Justice Roberts was forever after referred to as the switch in time that saved 9. Oh, so good, so good. It's like something you'd see on Amazon having to do with I don't know, a superhero type person. All right, the Supreme Court cases. 3 Social Security cases made their way to the Supreme Court during October 1936 term. One challenged the old age insurance program, Halvering v. Davis. And the two challenged the unemployment compensation program of the Social Security Act. The court would issue rulings on all three on the same day. And just to like clarify, like how big of a deal that is and how difficult it would be for the court to line all of those decisions up with everybody's writings and everybody's dissents all at the same time, in that this was a military strike level attack from the Supreme Court against the president. That's what this was. This was huge. This was an internal, some might even say this was its own version of, like, a civil war, except it was between the Supreme Court and the president. Okay. All right. Halvering v. Davis. George P. Davis was a minor stockholder in the Edison Electric Illuminating Company. Edison, like every industrial employer in the nation, was readying itself to start paying the employer's share of the payroll tax in January 1937. Because remember, the way it works is the employee pays some tax, the employer pays some tax, and that's how you get to the 12.4, and then you add some more to the 15+%, including the Medicare. Cool. All right, so bottom line is Mr. Davis objected to this, arguing that by making this expenditure, Edison was robbing him of part of his equity. So he sued Edison to prevent their compliance with the Social Security Act. The government intervened on Edison's behalf, and the commissioner of the IRS, Mr. Helbing, took on the lawsuit. The attorneys for Davis argued that the payroll tax was a new type of tax not listed in the Constitution's tally of taxes, and so it was, therefore, unconstitutional. At one point, they even introduced into their argument the definition of taxes from dictionaries in 1788, the year before the Constitution was ratified, to prove how earnest they were in the belief that powers not explicitly granted in 1789 could not be created in 1935, which is what we do in law. Like when we have a question of like what something is, we got to go figure it out. We'll look up lots of definitions. And then if we are a true, honest, direct attorney, we will go ahead and basically do a study as to the outcome of what all of them would give. Or if we're just trying to make money, we'll just pick whichever definition we like and go with that. That's how they do it. All right. Davis was also the point of view that providing for the government welfare of the aged was a power reserved to the states. The government argued that this was too inflexible, an interpretation of the powers granted to Congress, and loosely that if the country could not expand the interpretation of the Constitution as it stood in 1789, progress would be impossible, and it would still be 1989. They're not wrong. The problem is if you restrict people's ability to grow the system into new areas by basing it solely on what existed as definitions a year before the Constitution was created, then you're just going to basically never really grow. And to be fair, there was another thing going on, which was how are they going to be competitive against foreign interests, foreign nations, if they can't start to figure out how they're going to tax enough money out of people to build a ridiculous, massive military that does a conquest all over the earth to go ahead and ensure that there is, lots of oil and gold and diamonds and stuff, raw materials that can be used to bolster the likelihood of America being a strong country moving forward. Because remember, 1935, so once again, not explicitly granted in 1989, could not be created in 1935. Remember, 1937. Remember, what's coming all over the horizon, right? A big war. A big, total shitstorm war. 2 big W's. Something after it. That kind of war. All right, so with that said, Stewart Machine Company. In the Stewart Machine Company case, the unemployment compensation provision of the acts were disputed. The company dutifully paid its first unemployment tax installment of $46.14 and then sued the government to recover the payment, claiming the Social Security Act was unconstitutional. They want their $46.14 back. That's some buckets right there. And to be fair, that was a lot of money back then. Stewart made the same points as Davis about the meaning of the word tax and argued in addition that the unemployment compensation program could not qualify as providing for the general welfare. Carmichael versus the Southern Coal and Coke Company and Gulf States Paper. This was also a case disputing the validity of the unemployment compensation program. In this variation of the companies were challenging the state's portion of the federal-state arrangement. Unwilling to pay their share of state unemployment compensation taxes, the two companies sued the state of Alabama, declaring that it was the Social Security Act, which they deemed unconstitutional, that gave Alabama its authority to tax them in the way. And since they believed the act to be invalid, they did not have to pay the tax. Alabama differed, of course. It was again the same issues as in the two prior cases. So basically, simplifying, they were in a situation where companies didn't want to have to pay a new tax because the rich people don't want to have to pay more money for however many employees it takes them to produce the work product and products that makes the money. Now, what lesson can we garner from this? What knowledge can we fold into a paper kite and fly and then probably rip? Well, we will learn that if we intend to make the rich pay their fair share, that really cool and clicky and awesome statement is total shit. It will never happen because the rich have gotten smarter since 1937. And they are very good at paying for basically the politicians that they want to go and be in power. Because Americans vote for names that they recognize, which means they vote for people that are in the news a lot, which are paid for by rich people. Yeah, that's how it works. That's literally how it works. It's just okay. So with that said, keeping that in mind, if anybody ever tells you that the rich should pay their fair share, they're right. They're just wrong because it will never happen. So unfortunately, Mr. President Biden's 400 plus plan to raise the FICA tax so that people earning over $400,000 of earned income have to pay the FICA tax for all the dollars above that ain't going to pass. It's just not. It won't pass historically from what the human race inside America has thought and felt before. And it's not going to pass because, let's just call it like it is. The rich have the control. Mr. Justice Cardozo for the court, okay, on May 24th, 1937, this is the important part. Whenever you hear Cardozo, you know high levels of sassiness is about to, it's like, imagine the Supreme Court building, Cardozo is present. Imagine like DJ level lighting comes out. You're at a big show. The lights move, different colors, they blink. That's our guy, Cardozo. May 1924, 1937, the Supreme Court handed down its decision in 3 cases. Justice Cardozo wrote the majority opinion in the first 2 cases, and he announced them on what was, coincidentally, his 67th birthday. Oh, very nice, very nice. Mirroring the situation in Congress, when the legislation was considered, the old age insurance program met relatively little disagreement. The court ruled 7-2 in support of the old age insurance program. They said, look, people suck at saving. This is going to help them save. Giddy up. Now, even though 2 justices disagreed with the decision, no separate dissents were authored, which is interesting. You'd expect more like, people disagreeing and being like, no, I don't like this because A, B, C, D, E, F, and G. The unemployment compensation provisions, by contrast, were hotly disputed within the court, just as they had been the focus of most of the debate in Congress. The court ruled 5-4 in support of the unemployment compensation provisions, and 3 of the justices felt compelled to author separate dissents in the Stewart Machine case, and 1 justice did so in the Southern Coal and Coke case. Justice Cardozo, remember, blinking lights, wrote the opinions in Helvering versus Davis and Stewart Machine. After giving the 1788 dictionary the consideration he thought it deserved, he made clear the court's view on the scope of the government's spending authority. Quote, there have been statesmen in our history who have stood for other views. We will not resurrect the contest. It is now settled by decision. The conception of the spending power advocated by Hamilton has prevailed over that of Madison, arguing that the unemployment compensation program provided for the general welfare. Cardozo observed, there is need to remind ourselves, right, of facts as to the problem of unemployment that are now matters of common knowledge. The role of the unemployment itself, formidable enough, was only a partial role of the destitute or needy. The fact developed quickly that the states were unable to give the requisite relief. And you know what's beautiful about this? This is justice with balls. Like literally. You don't understand how tiptoey and light some judges have become. Now, Supreme Court justices, they still have cojones when they deliver a lot of decisions. Just they will slip their words. If you're thinking like that, mom in the South is nice to you but really, really mean, the Supreme Court justices are famed for their meanness in how they write. And you're sitting there feeling like they've just beaten you horribly. But at the same time, this is interesting. This is where a lot of this actually comes. The problem has become national in area and dimensions. There was need to help from the nation if the people were not to starve. It is too late today for the argument to be heard with tolerance that in a crisis so extreme, the use of the monies of the nation to relieve the unemployment and their dependents is used for any purpose other than the promotion of the general welfare. And what they were saying was, look, people become unemployed. What was happening in the 1920s. We have to have a system for them. People get old. We have to have a system for them. That's what he was saying. And finally, he extended the reasoning to the old age insurance program. Quote, the purge of the nationwide calamity that began in 1929 has taught us many lessons. Spreading from state to state, unemployment is an ill, not particular, but general, which may be checked if Congress so determines by the resources of the nation. But the ill is all one, or at least not greatly different, whether men are thrown out of work because there's no longer work to do or because the disabilities of age make them incapable of doing it. Which is a cool quote because it would take all the way into the 1950s for them to create SSDI benefits. But they're talking about the first disability that they really wanted to promote with the social insurance program, which was you get old. Oldness is in itself a disability. Rescue becomes necessary irrespective of the cause. The hope behind this statute is to save men and women from the rigors of the poorhouse, as well as from the haunting fear that such a lot awaits them when journey's end is near. I've always liked that sentence because it spoke very heavily to the future of how women were going to be part of the workforce. What's interesting is you see a lot of women now on TikTok and Facebook Shorts and stuff like that and YouTube Shorts talking about how angry they are about how the transition from where they could just be housewives raising their kids to now having and being forced to work, and how they're angry about women passing these rights and these strong women doing these things back in the day. But the Supreme Court justices, they knew what was coming with the cultural shift. And yet they were supposed to be these ancient men of ancient times where there were dinosaurs and caves that they dwelled in. The joke about dinosaurs was a Star Wars joke, lightsaber to the belly and you're in. This hope behind this statute is to save men and women from the rigors of the poorhouse, as well as from the haunting fear that such a lot awaits them when journey's end is near. With these cases decided, Justice Stone could then dispose of the third case in short order. Together, the two statutes now before us embody a cooperative legislative effort by the state and national governments for carrying out a public purpose common to both, which neither could fully achieve without the cooperation of the other. The Constitution does not prohibit such cooperation. So just to summarize for those who are joining us now, we would not have the Social Security Act today. Retirement, disability, supplemental security income, spousal, survivor's benefits, disabled little child benefits, 303s. We wouldn't have any of that stuff, but for a president basically saying, hey, if you're an old justice, I'm going to put some more people on the bench to cover your load because you can't cover it. That pissed off these old men so much that it caused a flip that allowed us for these social programs to exist. So if you're ever wondering, when was the biggest socialist-based thing ever created, it would either be during the 1930s when the Supreme Court allowed, and also was created, but when the Supreme Court allowed these programs to continue because they got pissed off at the president, or it was when Nixon passed supplemental security income, because supplemental security income is the princess, the queen, the prince, and the queen of socialism programs. Now, with that said, The Social Security Board breathes a sigh of relief at that point. Putting the Social Security Act into operation was a massive challenge. In some respects, it was unprecedented in American history. The record keeping involved was on a scale never before attempted. The Social Security Board could ill afford to wait until a definitive Supreme Court ruling was issued before starting to work. Issuance of Social Security numbers, collection of payroll taxes, and payment of the first lump sum benefit all had to start by January of 1937. And the board was to have to hire staff, acquire facilities, set up record-keeping procedures, and a million other things before then, all of which it did without knowing whether its actions were constitutional. By the time of the court's ruling in May of 1937, more than 26 million Social Security numbers had been issued. A lot of people don't realize, like, when they think about Social Security numbers, everybody just assumes, like, the moment Washington did his thing, they came into existence. That's not how it happened. Like, a lot of people are just like, when Washington crossed the river and had his knee in the air and his sword by his side, and like the Viking music starts. Like, a lot of people assume we just had what we have now, but no, we didn't. It was different. Their socks were different. That's just how it is. It's important to know that. By the time the court's ruling in May 1937, more than 26 million Social Security numbers had been issued. Around 150 million in taxes had been collected. A dozen or so benefit claims had already been paid, and there were about 150 local field offices in operation around the country. So, to be fair, they were kicking ass and taking names. So we can well imagine the tension felt by the board's employees as the court assembled on that Monday morning in late May to hand down its rulings. Making law. The board's general counsel, Thomas Elliott, has given us a description of that moment. Here we go. Finally came the great Monday, which nobody ever says about Monday. Monday was the court's decision day, when the Chief Justice announced the name of the first case to be decided, Halvering v. Davis, in which the constitutionality of old age insurance was challenged, and signaling that the court's opinion was to be read by its author, nodded to Justice Cardozo. Remember, blinking lights, it's like they're at a rave. He's the one. When he walks in the room, glowing balls, the whole thing, somebody's at the Neve board pushing the volume up, that kind of stuff. Victory! My letter of May 25th began, Dear Mon Pa, yesterday was a big day. I hadn't really expected the decision until next week. The result itself was not so surprising, but gratifying nevertheless. Late yesterday afternoon, Lois and I went down to see Miss Perkins and split a bottle of domestic champagne with her. Sounds like old people talking about old times where they had like tweed briefcases and stuff. So adorable. So damn adorable. Now, these are the men, I'll show you shortly, who are shown leaving the Supreme Court building after the rulings, are a happy group of administrators. Murray Latimer, Railroad Retirement Board Chairman. R. Gordon Wagonet, no idea how to pronounce his last name. Unemployment Compensation Director. Arthur J. Altmeyer, Chairman of the Social Security Board. And Frank Bain, Executive Director of the Social Security Board. These guys were digging it. They were happy. They're like, yeah, buddy. Yeah. They were doing the yee right there. All right. Now that we have covered this, this is basically the thing that gives us the Social Security Administration that we have today. It was, in many respects in America, the foundation of socialism that was tolerable to the American people, the president, well, kind of the president, the Supreme Court justices, and the legislators. And legislators put it through. The irony of this situation is that Social Security, the entire system, has never really been something that was voted on by everybody. It just never has. And the fixes for it, just to be fair, have always died because of some weird thing that happened, right? And I think the weirdest thing for me is that a lot of the fixes that occurred 1930s. And then, of course, you have these big fixes. Republicans are on board. Democrats are on board. Everybody's on board. It's Bill Clinton's era. And what happens is you have the whole controversy with Monica Lewinsky, who I'm sure one day will ironically be stuck with the Social Security program failing to some degree, like the retirement, trust fund running out. Not that it's her fault in any manner. It's not. I mean, this is purely a two people had a little bit too much fun in an office kind of gig, which happens. I'm not saying, it happens. But again, there are these moments in history where Social Security, the program, the thing that we are going to rely on, the thing that so many people already rely on, the fixes don't happen because of some weird personal thing that happens or some oddity occurs. My point with this is that ultimately, and I think this is incredibly important, at the end of the day, we will have to see somebody, whether it's the Republican candidate, a Democrat candidate, whatever, who's willing to have the bravery that these Supreme Court justices had to fix this program going forward. And the kicker is that nobody can really afford to pay more taxes. There's a lot of reasons. The economy is really bad. Student loans are horrific. A lot of reasons. And now they're out of money to be able to borrow and out of money to go ahead and print. Because if they print more money, they'll just destabilize their international reserve currency even more. So it's going to be really interesting to see what happens in the future as to whether or not Social Security benefits exist in the way that they currently do. Because and I'm going to tell you a secret. The people who are going to decide Social Security benefits are not Supreme Court justices. They're not the president of the United States at the time that the shit goes down. It's not the legislatures, the House or the Senate. It's not the local community leaders. It's going to be a stab match between basically those who are older and retired and those who are currently paying for their retirement. So boomers v. millennials. That'll be like literally the case situation. Now, with that said, I don't know why people keep mentioning squirrels in the chat section, but good job. I will catch you all at the next video where we talk about another right that I think is not going to I think the courts decided this one right here, and I don't think it's going to exist into the future. The courts have now decided whether or not alimony is something that will be upheld as a benefit that can be considered and money to be taken from Social Security, disability insurance benefits, and retirement benefits, which is ironic because there were provisions supporting that, but now they officially have the court ruling on it. We will go over that and all of the women and men, although it's obviously more women than men, who will in the future benefit from that. All right. I will catch you guys a little bit later. Please remember to like and subscribe. The next one we're going to be doing is the rules on benefits being assessed for income for alimony. With that said, please remember to go to Google, type in Disability Resolution Law Firm or Disability Resolution Florida. Please remember to go to Google, type in Disability Resolution Law Firm or Disability. Hit that. Remember, I go live on Tuesdays and Thursdays to answer questions. So tonight I'll be live. I'll answer some questions. And then finally, if you need me to figure out a tough thing that you're going through with the Social Security Administration, there's a little mini contract in the thing below where you can basically hire me for a private 1-hour sesh. All right, I'll catch you a little bit later. I will see you at the next video where we talk about alimony and how the courts have officially ruled on it. I'll catch you a little bit later and see you soon. All right, bye-bye, everybody. Bye-bye.